me ask you about these governors who are saying, no, not in my state. You're not. Larry Hogan, latest, yesterday, governor of Maryland. There will not be one Syrian refugee in my state. John Kasich in Ohio. Bobby Jindal in Louisiana. They're all, particularly, one Democratic governor, but all the rest are Republican governors who have said that. Do they have that authority?
Absolutely not. The Constitution is exceptionally clear that the power to determine a uniform and national, those are the words used in the Constitution, policy when it comes to naturalization and immigration belongs to the federal government. You add to that the federal government's exclusive authority to deal with foreign powers, and obviously the way we treat citizens of other countries in our borders is something that is keenly tied to the interactions with other foreign powers, because we have citizens who will be in those countries and we care about how everyone is treated. So the idea that you can have a governor say who can and can't come within its borders, that's absolutely unconstitutional. And I don't know if these folks are just ignorant of the Constitution.
I was just going to say, they have to know that,
I
right?
would think so. I mean, not only does the Constitution's text say it, but the Supreme Court has said it over and over and over. We saw it most recently with Arizona's Show Us Your Papers law, where the Supreme Court again said, no, actually, the ones who decide how immigrants and refugees and people who are here who are non-citizens are treated, that's the federal government. And frankly, once you're within the borders of the United States, we also have the Equal Protection Clause. And that says that that persons, not citizens, persons all deserve equal treatment. So you can't say, because of your national origin, I'm going to treat you differently. Right.
So have you read Notorious RBG?
So I confess I have not read it yet, but I'm very excited to do so.
So Ruth Bader Ginsburg, we had the author in a couple of days ago. I mean, she is a rock star.
She's a total rock star. Oh, my God. She's like, I watched her put the authors of the book through her workout on, I think it was on MSNBC.
No.
Yes,
really?
and they, could not even do it. It was hilarious. So, those of us who are like, people who are like, she looks frail. She, like those young girls who wrote that book, they couldn't make it through.
So
don't count out Justice Ginsburg.
She's not going anywhere.
Yeah, exactly.
Right? She's going to stay on the court.
Well, she said that she'll stay on the court until she can't do her job anymore, and she certainly seems like she's firing on all cylinders. Right. I don't expect her to retire until she has to.
So this is going to be every session is an important session, but this is going to be a particularly important session for her. A lot of big cases coming up. The one that got the most attention recently is the Texas case on abortion.
Yes.
Which would effectively, you explain what the case is about.
Yeah, so there have been states led by Texas, also Mississippi, that have created these sham laws that pretend to be about protecting women's health by requiring places that provide abortion services, as well as many other preventative health services for women, to basically be the same as a hospital surgical center. So they have these building requirements, facility requirements.
Where you could do brain surgery, heart surgery, and all this stuff, the same standards.
Exactly.
Right.
As well as requiring doctors who provide abortion services to have admitting privileges at local hospitals. Now, the American Medical Association, the College of Obstetricians and Gynecologists have said that these sham laws absolutely have nothing to do with women's health. They don't promote women's health. What they do is effectively shut down clinics in these states. In Mississippi, if the law went into effect, I think there would be they would lose their remaining open clinic. In Texas, it would shut down all but I think 10 clinics. Texas is a large state. That would require women to travel hundreds of miles.
Right. And in Mississippi to go to another state.
To go to another state. And so the Supreme Court has just accepted review in this particular case out of Texas. And it's really going to be the biggest abortion access case that the court has heard in a really long time.
And there was a similar case, not recent, there has been a similar case, right, which was a 5-4 Justice Kennedy, the deciding vote. So is he the pivot here again, or the?
Definitely all eyes will be on Justice Kennedy. So the court has said, obviously we all know in Roe versus Wade that there is a constitutional right for a woman to determine whether to end or continue her pregnancy. The court has then, after that, said that you can't place an undue burden through state law on that right. Now, states can, try to promote childbirth, but you can't place an undue burden on the ability to access an abortion. And so the question is, are these sham laws an undue burden on women's right to choose whether or not to end her pregnancy? And, I think basically the feeling is if these laws aren't an undue burden, the ones that basically shut down all the clinics in one state and almost all of them in another, what is an undue burden if this isn't it?
When will this case be argued?
I think it'll probably be late March. They haven't scheduled it yet because they just granted review last Friday, but probably late March.
So this session of the court is already underway.
Yes.
Right?
Yes.
They've already started hearing cases? Or?
Yes. So they've heard cases. They're still continuing to grant cases. We are very closely watching that grant calendar because we also are waiting for the appeal from the Fifth Circuit's decision on the president's immigration initiative that defers removal for parents of American citizens. And so you basically, all the cases that are granted, you kind of have to have the court take up your case by January if you want it to be heard this term by the end of June.
All right. So with the immigration case, is it or is it not on this year's agenda?
So
this term's agenda?
At this point, it hasn't been filed yet with the Supreme Court. So the Fifth Circuit Court of Appeals issued its ruling saying that the DAPA program and the expansion of DACA is invalid. And now the government, the Obama administration, is deciding, and they have told us that they will file with the Supreme Court and ask the Supreme Court to overrule that. But the Supreme Court has not accepted the case yet, so all eyes are on the Supreme Court to see whether they do accept that case in time.
They have to accept the case first. If they don't accept the case, is the extension of the DREAM Act then by executive order inoperative? Or?
Exactly. So this is a big deal, and everyone should be watching the court to see, to make sure that they're acting expeditiously because,
Why can't somebody else appeal it to the Supreme Court? Oh, I guess they have, right?
Yes. So the Department of Justice has said they will take it to the Supreme Court. I would expect that cert petition to be filed, frankly, any day now.
That's a hugely important case. Was the Fifth Circuit's decision that President Obama exceeded his constitutional authority?
So it wasn't a constitutional ruling. It was sort of on a more procedural ground on the Administrative Procedure Act. But the gist of the Fifth Circuit's ruling was that the president was going too far beyond the discretion that he is given. But that's absolutely wrong. While there is a substantial amount of discretion delegated to the government, it's within the statutory scheme that Congress has set up with respect to immigration. Congress has been clear that they want the president and the executive to be making the decisions about how resources, when it comes to focusing on which people who are here illegally to remove first. That only makes sense. And Congress has said that. So the president is entirely within his authority. And frankly, I filed a brief on behalf of a bipartisan group of former members of Congress. So, presidents of both parties have been doing this for decades. It really shouldn't be this divisive left-right issue. It just is common sense.
But, and particularly in this case where Congress could have acted but didn't act, refused to act, frankly. And so as President Obama, every time he's done something, he said, okay, you don't like it? Pass a bill.
Right, exactly.
Come on, have a debate, pass a bill, do something. And we didn't even get yet to contraception and affirmative action. Yeah, right. Oh, man, it's all coming down at once.
It's a blockbuster term once again.
It is indeed. And Elizabeth Wydra here. From the Constitutional Accountability Center, a question or comment, good time to get it in at 866-55-PRESS. Congressman John Yarmouth, Kentucky. Is today the day he's bringing the bourbon?
One of these days.
Oh,
it's promising,
One of these days.
I hope it's today.
Yeah, right?
That's right, while you're still here.
Right.
The Bourbon Caucus.
Yes, he is. Yeah.
The Bourbon Caucus. Coming in at the half hour. We'll find out right now with Elizabeth Wydra, a little drier topic.
Sadly.
But pretty important, the U.S. Constitution and the Supreme Court tested again on the issue of contraception. The opponents of Obamacare just won't give up.
No. It might drive you to drink a lot of bourbon.
Yeah, right.
Not only will they not give up on the ACA in general, but this actual issue is back at the court for the second time.
And I thought it was, it was decided once. Why didn't the court just say, hey, read our last opinion?
Yes. So last time the case came up, so the Affordable Care Act, in providing preventive services that have very positive health benefits, when it comes to women, they said that
Health plans should cover contraception.
Exactly, without cost to female employees and their families. And Hobby Lobby, the case that was up before the court a couple years ago, said that small for-profits that object to contraception coverage because of religious beliefs, that they can get an accommodation where their outside third-party insurer will provide the coverage, but they can sign a form saying that they have a religious objection, and then they're cut out of the process completely.
Right.
The court noted that this accommodation already exists for religiously affiliated nonprofits like universities that are Catholic, etc. They noted that in the opinion. Well, now these religiously affiliated nonprofits like Christian colleges, etc., have sued and said the accommodation that you said was good enough in Hobby Lobby, we don't think is good enough, because we still think that filling out this form so that a third party can provide the coverage to women and their families, that somehow still implicates us. So the issue before the court is this a substantial burden? It's important to note that the law requires a substantial burden on religious exercise. And the government has bent over backwards to accommodate religious liberty. They said, we get it. We don't want to force you to provide contraception coverage. That's why we're cutting you out of the loop through this accommodation.
And the court's going to have to decide. It sounds to me like these people don't have a really strong case, but who knows what the court will do.
I mean, they've lost in all of the federal courts of appeals except for one. So, going up, there is a strong case behind it. And, the government really has tried hard to balance the interests of religious liberty and the important interest in women in getting access to contraception.
We'll be watching with you, Elizabeth Wydra. Thanks for coming in.
Absolutely. Thanks for having me.
This is the Bill Press Show.